Welcome to the Assureology Show, a growth hacker's guide to human capital management with your host, Mike Vannoy. Each week, we bring you experts in human resources, employment law, accounting, benefits planning, and more to build productive organizations. You'll gain practical guidance for your business. You'll be alerted to the latest news and mega trends that impact small and mid-sized companies. We'll give you the hands-on information you need to stay compliant with ever-changing employment laws, the strategies you need to win the war for talent, and much more, so you can focus on what you do best, growing your business. Enjoy the show.
OSHA, what all employers must know. Hi, my name is Mike Vannoy. I'm Vice President of Marketing at Asure. And this is a topic that maybe if you're in the construction industry, you know exactly what OSHA is. You live by those safety standards every single day. But an awful lot of employers, whether you're a white collar, a retail, blue collar industry, so many business owners don't realize they must comply with OSHA rules that they wouldn't even think of. So a great guest, probably the perfect guest to unpack this topic today. If you're a regular watcher of the show, you know Brian Shenker. Brian is a counsel at Long Island, New York office of Jackson Lewis. Brian's practice focuses on representing employers in a wide range of workplace matters, as well as preventative advice and counseling. Brian has extensive experience defending class action lawsuits under federal and state wage and hour laws. He has successfully defended wage and hour audits conducted by the U.S. and New York State Departments of Labor. And Brian regularly handles cases before courts and administrative agencies involving claims of discrimination, sexual harassment, and retaliation. Welcome back to the show, Brian.
Thanks for having me, Mike.
So I think probably everybody's heard of OSHA. Like I said at the opening, you know, if you're in the construction business, you know probably rules, whether it's ladders and helmets and safety equipment and harnesses and whatnot. But I think so many employers don't. So I think it's really important because this applies to all businesses. But let's just really step back and make sure that we cover this thing comprehensively. First of all, what is OSHA? Ironically, OSHA, the acronym, is both the act and the governing agency. Bring us back to 1970 and tell us what OSHA is.
Right. So in 1970, that's when Congress created the Occupational Safety and Health Administration. And that's OSHA, also the Occupational Safety and Health Act. It's almost interchangeable how we use that. But OSHA was designed to ensure a safe and healthful work conditions for workers by setting and enforcing standards for the workplace by providing training, outreach, and education. So OSHA is an agency of the federal government. It's responsible for promoting workplace safety nationwide, and it has the authority to oversee compliance with safety and health laws. So what does OSHA really do then? So it's required by law to regulate the workplace hazards to employee safety and health. It does this through specific regulations or, as we'll discuss in a little bit, the general duty clause, which is, widely applicable.
So Brian, it's not going to be possible to list every single use case. But maybe give some examples, especially for those folks who maybe watch the show regularly, but think maybe this one doesn't apply to me. I don't know should I continue watching. Give us some examples of traditional white collar jobs and in work environments where OSHA absolutely still applies.
Right. So look, if someone falls in the workplace and injures himself, that's a potential OSHA incident for which there may need to be, record keeping and, other remediation done. Same thing with, repetitive movements can cause injuries at the workplace or being struck by equipment. This isn't necessarily, stuff that only applies in construction or manufacturing. In offices, for instance, there are emergency action plans we'll discuss, which are policies regarding what happens in the event of an emergency or a fire in the workplace. Who decides, where do we go? What happens? What do we do with, doors? Do we leave them open, closed? Things like that. And as we'll get to the general duty clause, even, in an office, right? There are many things that can, become issues, right? Ergonomics type things, or, as we saw during the pandemic, wearing, respirators, face masks, things like that may be covered by
Sure.
OSHA. And so, the main key, really, the overarching theme that we'll discuss today is that, each business, whatever line of business you're in, whatever your workplace looks like, has some hazards. And OSHA requires, businesses to identify what those hazards are and, take reasonable steps to eliminate those hazards or, reduce, how hazardous they actually are.
Right. Okay, so maybe let's start kind of with the basics. So I think that covers it. Like, hey, we're a law firm. Well, look, bad example. You know the law, but we're an architectural firm. We're an engineering firm. Just think carpal tunnel typing, right? That is an actual work hazard. Got a squeaky front door that you got to push extra hard, and you fall coming through it. That's a work hazard. So this isn't just about safety helmets, harnesses, and ladders. This really is every aspect of your workplace. We won't go down this rabbit hole, but this was where the government was kind of playing with some COVID restrictions in contemplating how far the government goes in a safe workplace, a safe work environment as it related to the pandemic, right? So just to be clear, this affects everybody. So let's maybe start with some of the beginning, the most remedial requirements of employers. And I think at the top, it's probably posting requirements, right? What are the obligations of an employer to notify employees of OSHA regulations?
Right, absolutely. So there are posting requirements. There's, the general OSHA poster, which is available on OSHA's, website. It informs workers of the protections offered by the act, like other workplace posters, like the federal minimum wage posters. It needs to be displayed in a conspicuous place where employees can view it. It's available in several different languages, depending on what your workforce looks like. And in addition to that, posting, there's some other requirements. For instance, if your organization is ever subject to a citation from OSHA, then OSHA requires the company to post that citation in the workplace, in a prominent place, possibly even where the incident took place, and that it needs to stay there for at least 3 days or until the company abates the hazard. Those are the main posting requirements. There are other, record keeping requirements, and, employees have access to certain documents. But generally, those are, the things that are going to be posted, along with, so we'll discuss, the OSHA, 300, 300A, and 301 forms. Those are also, made available to employees.
Brian,
So
before
unlike
we
some of the
move
other
on, before we move on from posting, because I think record keeping will hit next. So the world is changing here, right? So I think everyone is familiar, as an employee, as an employer, you've come across it in your life. You see the safety posters near a punch clock, a time clock. Maybe it's just in the general break room. Maybe it's the door where employees enter a facility, right? So we've all seen that. Can you speak to changes, or how is this evolving in a world where workplace geography might not matter as much, right? Whether it's completely virtual employees or flexible workplace employees, right? So if I'm an engineer, I work for an engineering firm, or I'm an architect, we already talked about, workplace hazards of tripping. Okay, probably not liable in my home, but if it's I'm typing all day, or I'm using a mouse in a very specific way, I'm vulnerable to, say, carpal tunnel. Whether I'm working from home, whether I'm working from the office, I will probably get to this. I'm assuming it's something that the employer still must notify the employee. How does the posting requirement work in that kind of a scenario?
Yeah, absolutely. Remote work is changing the way we really think about these posting requirements, not just for OSHA, but for other ones. So, I think the tried and true method of posting the physical copy of the poster, in the workplace, like the break room, still advisable. But in addition to that, what is often a good best practice is to email these posters to employees at the outset of employment. Right there, most of these forms are either readily available online or available through, Asure is your payroll provider, or HR service, can provide them. So you have these electronically, and especially for remote workers, but even maybe for, everyone, just as a good reminder of, here's these documents. There's a reason they're required postings, because they give employees pertinent information on certain protections and obligations. So emailing them. I've also seen companies go another step and also post them on their internal intranet, so they're available there. But really, these are things where the more you put it out there, that just shows your company's good faith and your efforts to comply. So you really can't overdo it with the notices.
Say more about that. So the law requires the employer to post. How this goes into gray area almost immediately, I would assume, because you can't create a law that covers every single unique facet of every workspace, whether it's lighting or access and wall of it. I mean, where do you put things? So what is the bare minimum legal requirement for posting?
So again, if we're talking about actual, postings about, hazards in the workplace, as opposed to this general poster, then, right, for instance, if we talk about, say, hazardous materials, right, then OSHA has, certain standards that may be applicable, to those, a hazardous chemical that's coming in needs to, have identified on it, the ingredients, what the actual hazards are, various things like that. So, right, in addition to the general posting requirements, depending on the industry that a company is in, and depending on what the hazards are, it may require other postings, like I said, for hazardous materials or for certain machinery. Right, there might be certain information that needs to be posted on a machine, identifying certain information about use or potential misuse or hazards. So those are things where again, we're talking about every individual company, and the hazards at each company are going to be different. And this kind of also brings us back to that general duty clause, where that requires every company to furnish employment and a place of employment that's free from recognized hazards that are likely to cause death or serious physical harm. And to comply with the safety and health standards under the Act. So to take affirmative steps and post things around the workplace, is something that employers should be looking to do. Right. I mean, the first step is obviously to recognize what the hazards are. Right. That's the key to this, to the company's general obligations under OSHA. And then the question is, for this general duty clause for things in the workplace that might not be covered by one of the industry standards, it's really up to the company then to, recognize the hazard and determine, the means of, correcting that, and, how to reduce any, potential hazard that exists. And so absolutely, depending on, even outside of the required postings, that may include, other postings around the workplace about, right, for instance, I can think of a restaurant, right? You have a door that goes into the kitchen, and it swings both ways, right? So people could be coming in or out. There, maybe that's a hazard, right? Someone could get slammed in the face by that door if someone's coming through at the same time. Maybe there needs to be steps and, a notice next to the door saying, watch out, so, something like that. So the hazards for each workplace are so different. And OSHA requires employers to really do an assessment of what those are. And posting around the workplace about those hazards is certainly one of the many things employers, can do, because you want your employees to understand what the hazards are so that, they can take steps and the company can take steps to protect them.
Brian, what about, so I got two threads going in my head here. I guess the first one, we talked about like remote employees. Is it safe to say, one of the maddening things we talk about on this show all the time is that in one way, HR laws are pretty black and white. FLSA is black and white. OSHA, the way the laws are written are black and white, but the way they get implemented, measured, quantified, and inspected, it's very nuanced, right? So on one hand, there's minimum requirements, and I think you did a good job explaining how it's not as simple as what are the minimum requirements, because it's going to depend on what are the requirements based on what the hazards are, chemicals versus space versus whatever. But it's safe to say that like if you get investigated, so an employee has an accident, they report, they get a lawyer, they sue, and you become inspected and audited by OSHA, human beings get involved, right? And there's going to be a human being employer, there's a human being judge, there's a human being attorneys, and good faith matters a lot here, right? So if you can say, hey, it's a remote employee, but it's in our employee handbook, it's part of our onboarding process. Let me show you what that looks like. Here's the time date stamp that they acknowledge that they received it, or even a signature that they received it. We put it in the break room here, and they don't come in here very often, but it's also on the back door, and it's also on our intranet. And just without being obnoxious, the more you can demonstrate a good faith effort, that means an awful lot, doesn't it?
Absolutely. So, we'll discuss the fines and, the penalties that are available. They are large, especially for, more serious, and willful and repeat violations, are in the six figures potentially. And those are maximum. But one of the things that OSHA will take a look at when, they are determining the size of a penalty is, right, the good faith, efforts of the employer, to comply. So, in addition to looking at the gravity of the violation and, history of previous ones, good faith exhibited by the company is very important. So that means, a company that ignores OSHA, regardless of what industry, and then has a violation, right? You're not going to be able to show good faith. But, if you as a company, you've gone through and you've assessed the workplace, tried to determine what the hazards are, you're aware of, the hazards that are generally applicable to your industry, and, you've tried to lessen those, that's something that will, be considered. Obviously it's difficult to avoid or remove every single hazard. And that's why, a lot of things like, for instance, personal protective equipment, and I'm not speaking about that in with respect to, COVID, but more towards, other, workplace issues, right? That, things like that are almost seen as, a last resort for safety, right? To protect the eyes, face, from, chemicals or heat or, material or debris. And that the company should be looking at, other proactive ways to, limit those hazards. And so, OSHA will look at these things. So that kind of brings me to, so there are a variety of ways that, an OSHA matter can begin. Really, triggering events can be a severe injury or illness in the workplace, or an anonymous complaint to OSHA, or referral from another federal or state agency. There are also targeted inspections on certain high hazard industries like construction or manufacturing. And that OSHA inspector is going to come into your business, usually with no advance notice, and they're going to walk through your place of employment, the workplace, just like the company already should have done. And they're not only going to identify hazards applicable to maybe whatever that injury is, but if there are hazards they see in plain view that have not been addressed by the company, right? I'm thinking about, look, let's talk about an office. Maybe there's wiring, there's exposed wiring, or, it could be, a whole host of things that you mentioned, a door that, a heavy door that's not working properly, right? Those are hazards that will be identified and, can then become part of, the penalties. So for employers to, turn a blind eye towards these things, when OSHA eventually comes to your workplace, they will identify these things. And then, right, whether you've shown good faith, that's going to be a big question, right? So proactively addressing these things, we can't avoid all accidents from happening, right? That's for sure.
Yeah.
But you can show that it's something you've taken care to try to prevent.
Brent, we've talked many times about how you can't contract around the law. So, for example, if more than 40 hours a week is overtime, according to FLSA, you couldn't make a side agreement with an employee to work 80 hours one week and none the next, and there would be no overtime, right? So you don't get to make contracts outside the law. How would it work? So let's say you've posted, here's the hazardous situation. Here are the hazards. Here are the safety protocols. But the employee simply ignores, whether accidentally or willfully. They just simply don't. They don't heed the warnings, the signs, the guidance. How does this fall under OSHA versus, say, just civil action of a disobedient employee, a non-compliant employee?
Right. So, obviously, my first response to that is, managers, supervisors should be on the lookout for this, right? If you as an employer require, certain employees to wear, goggles or something like that, or, take certain steps, for instance, in a salon, wearing, latex gloves when you're working with certain chemicals, if as an employer, there should be some monitoring of that, right? That one of the elements of, preventing these types of hazards is oversight, right? So we don't say, the easiest example is in manufacturing, right? We don't just send all the employees out to the manufacturing facility, say, yeah, we've trained you, now go do it. The supervisor is going to sit in their offices and wait till the bell rings and make sure you've done all your work, right? No, the supervision should be out there. Supervisors should be, ensuring that employees are following protocol. So again, we can't control all situations. If employees are, just ignoring these and, an accident happens, then obviously there can be a factual defense to the claim, by the from OSHA, by the employer that, hey, we've taken precautions. We've, complied with
Yeah.
industry standards and, our general duty standards. And in this instance, despite our supervision, this employee, took off her latex gloves, and, it was, we can't be, have eyes on them 24/7. So, you would, argue that it's not the employer's, the hazard that wasn't identified by the employer that caused this serious harm. So there are you can contest these OSHA violations certainly, and that might be a basis, but I think employers shouldn't just feel that I've put something in a policy, I've done my job, I've posted a warning, at that entrance, I've done my job. If there are very clear instances of, employees not complying or, just ignoring those things, the company, should be aware of those and take action.
Yeah. If you have the sign that says boldly, safety glasses must be worn at all times beyond this line. Okay, great. Maybe that's an OSHA requirement, but you're not off the hook. I mean, a judge or an inspector is not going to let you off the hook if there's clear documentation and evidence that supervisors don't call you out and punish or hold people accountable to actually doing it, right? So the sign in of itself,
right.
if like you said, you can't watch everybody 24/7. If somebody had their glasses off, they get injured, okay, you'll probably be okay. But if you have other employees who are going to testify, or God forbid, there's video evidence of supervisors walking around not holding people accountable to always having their safety glasses on, I mean, you may as well throw the sign away at that point, right? You're on the hook. It's not just
absolutely.
Posting. Yeah. So
and
so it's
I
not
think
just
that
a
also
posting requirement.
Yeah.
You have to live it. You have to demonstrate
Right.
this. Yeah.
Yeah, and I think that goes toward training and education of the workers too, right? That OSHA has some specific training requirements for certain industries or circumstances. Some of the more widely applicable ones, we'll discuss emergency action plans. Every company should have an emergency action plan, and employees should be trained, how to assist or what to do, to effect an orderly evacuation of other workers. Hazardous waste or an emergency. Yeah, go ahead.
Yeah, let's do that because, and I'm looking at notes here, the buckets that I wanted to hit here, and I think we'll come back to record keeping as one of the last ones. We'll talk penalties and record keeping last, but it's the emergency action plan and training and education. And I think these two things kind of are intertwined. So whichever one you want to pick first there.
Yeah. So why don't we speak about emergency action plans? Because, this is something that, may be overlooked by, a lot of businesses. And, each, business should have, we'll call it an EAP, an emergency action plan. So an EAP is a written document required by OSHA standards. The purpose of it is to facilitate and organize employer and employee actions during a workplace emergency, right? It basically describes how employees should respond to different types of emergencies that take into account, the employer's specific, worksite layout, structural features, emergency systems. It's very particular to your operations and what that looks like. Generally, in terms of putting an EAP together, an employer is probably, it's probably recommended to not just include management, but include employees too in the planning process, because this is going to be applicable to employees. Their viewpoint may be helpful as well here. There are some, minimum requirements for this EAP, right?
Brian,
and again, what are we talking about? We're talking about.
Yeah, is the EAP, does it need to be a standalone document that is reviewed? Can it be just part of the employee handbook?
Yeah, it can be part of that. If it's part of a handbook, I would even have it as a separate section, just to, separate set of pages, cut out of there, just because it is so important and affects safety. I mean, this is something that in the event of a fire, an explosion, depending on, leaking of hazardous materials, it's going to contemplate these things. And, it's something you don't want hidden on page, 75 of the handbook. So, it's good to kind of be, a separate thing, just so that, employees are aware of it and that it's, something that they do review. And look, it's something that, if you're like the office where I'm in here, there are, fire drills every once in a while, and you don't think about it, but the way you operate when there's a fire drill is according to the EAP, right? You go and meet in a certain location, perhaps employees are told to close doors, turn off machinery. So, again, the minimum requirements, right? So, it's going to set the means of reporting, fires or other emergencies. Yeah, that's pretty simple these days. We're calling 911, pulling a fire alarm, easy enough. Where it really gets into it, right, the evacuation procedures and escape routes. So employees, should understand, who's authorized to order an evacuation, right? A lot of businesses will have kind of a marshal or a fire marshal, within the company that, they're the ones that are responsible for telling, all right, it's time to evacuate. And that person, should know what are the conditions, what are the circumstances in which we will evacuate, and what routes we're going to take. Like I said, there might be requirements to close doors, turn off equipment, shut windows. Certainly, if there's a fire and you have machinery that, could be left on and potentially injure first responders, the EAP should establish that those machines should be turned off in the event of a fire, right?
And so Brandon, there's probably some people that will be thinking, okay, we work with hazardous chemicals. Here's the clear EAP action plan, employee action plan. Somebody falls off the ladder, a harness breaks, but we're going to talk about penalties in consequences of not following. I want to wrap on that topic, but just something as simple like a fire. So like you're a software company. This is white collar employees, and you're like, why does this apply to me? Do I really need an emergency action plan, an EAP, just in case there's a fire? Obviously, everybody just knows to run for the exits or whatever, right? We already know one bad thing happened. There's a fire, which is pretty bad, right? But what bad thing happens if I don't have an EAP in place if that tragic event happens?
Right. No, great question. So, right, let's say there's a fire, and in the midst of that, an employee gets left behind. Maybe someone's in a remote location where they don't hear the alarm system, or, look, you're not able to timely find everyone, and, maybe people don't know where to report to. There are problems, right? So that's why, one of the things that is required in EAP is, a procedure for accounting for all employees in an evacuation, right? Because, let's say there is there is a fire, right? Well, there might be an employee who is still stuck in the building. Maybe their way of, egress is blocked because of, the fire. And if you don't have a procedure for everyone to gather at a location and someone to identify who's here and who is not here, when the fire company comes, they're going to think, oh, we have a fire to put out. This is not a rescue. Maybe it is a rescue situation because there's an employee left behind. And now, and this can apply to a simple office, right? Where, you need to have that ability to tell them, hey, we can't find, Jane Doe. She's here. We don't know where she is, or here's the last location we know about, but you won't be able to give that information to, emergency personnel if everyone's just scattered and you have no procedure for identifying, that everyone has been evacuated. Another thing that's not required, but certainly in your IT scenario, it's something that EAPs can consider and include is secure or off-site locations for records. So that could be both paper or electronic, right? But if a company stores all originals in one place and there's a fire, what happens if those are burned? We have no backups, right? So some of these procedures are not just for the safety of the employees, but for the business, right? If we haven't considered, if your emergency contact list is in the office and there's a fire, well, how is someone accessing that once you're all outside and you can't get back in, and someone needs to contact someone's spouse that so and so is just been gone to the hospital, right? So a lot of these things are, if you don't plan for it, it's too late, because there are a lot of things that can go wrong. Right. But having the EAP and established procedures, really, you can limit what those are and put in those controls.
And that's a pretty
and again, talking about penalties, right? You don't act, you don't have this, someone gets injured, that's going to be a big factor.
Right. I mean, common theme we talk about. It's like there's the compliance part of HR laws, for example, OSHA requirements. Generally speaking, and obviously this stuff, and especially the modern world, kind of delves to the political realm, where maybe you don't always love every single law. Even if you agree with every single law, it can be overwhelming to keep up with it all. But maybe just as employers, just to be thinking, what's the spirit of the law, right? Whether it's overtime, whether it's minimum wage, whether it's leave requirements, whether it's workplace safety, even if no matter how frustrated you get, I would just coach people, what's the intent of the law? The intent is to provide a safe workplace. And by the way, if you do these things, it really is just kind of considered best practices. So if OSHA didn't exist, you would still want, a good plan what happens if a tornado hits? What happens if there's a fire? What happens if such and such scenario happens? These are just all really good practices anyway. Now, if you're a big company and you got some operations folks, some safety folks, maybe this is what they do. No big deal. If you're a small business and you're trying to just scrap out a living, you're trying to survive and grow your business on super lean margins, and this falls to you, after you put the kids go to bed at night because you got your day job serving customers, this can be really, really hard. But maybe just the coaching is all this stuff really is best practices in running a business. Am I oversimplifying that, Brian?
No, you're absolutely right. I mean, just if we consider the statistics, right? I mean, I think in 2021, there were 2.6 million non-fatal workplace injuries and illnesses reported by private employers. There were over 5,000 workplace fatalities in 2021. And so, there are a lot of injuries. Luckily, fewer fatalities, but that's a very, substantial number. And so, right. I mean, even if you're an employer not thinking about compliance with OSHA, again, you should, as we've said, it applies to all employers. If you just caring about the safety of your employees should be enough that you're going to take steps to reduce these types of hazards in the workplace, have these plans, and really put your workers in the best position to be safe. And again, for those who might not be considered about safety and are worried about the bottom line, look, workers who get injured are missing work, which affects your bottom line too. So really, no matter how you look at this, from the human aspect to the monetary aspect to the legal compliance aspect, there's lots and lots of reasons to take it seriously. And for employers who may have not considered that OSHA applies to them, let this be an opportunity to, take stock, start reading things, reach out to professionals, figure out how it applies to your workplace, how you might have hazards you haven't even considered, and what steps you should really take to protect your workers.
So, Brian, we talked about the requirements to post. So all employers, white collar, blue collar, doesn't matter. All employers must publicly post the safety requirements. You can hop on, we provide them for our clients, our HR services compliance clients, but you can get them on the OSHA website. You got to post, but we also talked that you have to then live that out. So if you have a hazard, the safety goggles must be required at all times. Then you can't let people walk around and not be held to account. So I'm assuming these emergency action plans, the EAPs, it's the same thing, right? So here's the EAP. You still have to enforce it. I think that's a good segue then into training. And I'm assuming there's a gigantic, maybe complete overlap between best practice to run a business anyway, and then training from an OSHA requirement. Let's start with a requirement. What does OSHA require by law the employers must train their employees on?
Right. So training is going to be dependent on the company's industry and really, the circumstances of, what the workers are doing. As I mentioned, the EAPs, that requires training to employees. It's not just develop a plan and store it away for that rainy day. No, it's something that employees should be trained on. Another, widely applicable one is, personal protective equipment, as I mentioned, PPE. Employers need to train employees who are required to wear PPE on, how to wear them, how it should be worn, right? There might be, for instance, a workplace that has, dust and debris, right? We might have, a mask that's required, right? Now, if an employee is wearing that, to cover their mouth and not their nose, it's ineffective, right? So there should be training on, it's almost like, I kind of think of when we're on an airplane and they're telling us, here's a seatbelt, here's how to put it on, here's an oxygen mask, here's how to put it on. Yes, break it down to the very simple things that, again, nothing is too basic here. This is your PPE. This is how we wear it. This is when you're going to wear it. Things like that. Hazardous waste operations. There's a hazard communication standard, right? So this is, educating employees about the hazards. So, a lot of workplaces have, chemicals that pose, a wide range of health hazards, from, skin irritation, to, being carcinogens, to, being even physical hazards like, flammability or corrosion or reactivity between chemicals. And so, OSHA has this hazard communication standard that ensures that, all hazards of chemicals that are basically, in the workplace are conveyed to the employees. So, containers will be labeled. There might even be pictograms and hazard statements, precautionary statements. There's a requirement to have a safety data sheet for these hazardous chemicals that, among other things, it tells you, what is this product? What hazards, are identified that it can cause? What are the ingredients? If there's exposure, what are the first aid measures? What are the firefighting measures? What are the recommendations for handling and storage, right? So those are actual things that the company is putting on these containers or essentially for these hazards, so that employees are aware of what they're working with and they know how to deal with it. And so OSHA requires an effective training program then to be conducted for all employees that could potentially be exposed to these chemicals. So there are things
and
like
the story's
that.
The same here as the story's the same here as it was with posting, right? It's like there's a minimum requirement to train. Am I safe in saying that the law doesn't get so specific that it prescribes exactly how the training occurs, but probably some minimum level of effectiveness or whatever? And so the coaching to employers is simply more is better. The more you can demonstrate that you've thought about this thoroughly, you provide lots of opportunities, more than just opportunities. You've held some type of accountability where you some type of auditability that people have gone through training. Is it as simple as thinking more is better, or are there some, and maybe I'm starting to tip into record keeping. What are there record keeping requirements of this training to make sure that I'm safe from a compliance perspective as an employer?
Right. So, yeah, I think on those points. So for some industries and some types of hazards, OSHA had, there are a variety of OSHA, safety and health standards. They can be found on the website, and some are for marine businesses, some are for construction, manufacturing, has hazardous chemicals. So some of those do require certain training or certain communications. But to answer the second question, sometimes it is more open ended, and it's more dictated by your own workplace and what the training might need to be for that. And then yes, as to documentation, this goes under a category of almost all things employment related, that it should absolutely be documented, who attended the training, when it was, if there's a slideshow or some outline for the training, keep that, because remember, one day OSHA can knock at your door unexpectedly, and you want to be able to show that you've taken steps to reduce risk. And so, yeah, you would absolutely want to show that employees have undergone, that training or, other, educational efforts.
What other record keeping requirements does OSHA put on employers, Brian?
Sure. Great question. So when we think of record keeping, there are three OSHA forms that kind of form the core basis of OSHA required records. There's the OSHA Form 300, which is a log of work-related injuries. There's the Form 300A, which is a summary sheet of those work-related injuries. And then there's the Form 301, which is essentially an injury incident report. If you're interested in seeing what any of these forms look like, they're all available on OSHA's website. And each of these forms has some specific requirements. So Form 300 is kind of that log, the workplace log, where it's not so detailed, but it contains information about recordable injuries or illnesses that have occurred that are work related. So just to break that down, we're not recording every injury or illness on this log. There's a couple requirements in order for a company to be required to put it in. So number one, we're mostly talking about companies here with some exceptions that have 10 or more employees. So again, this is very widely applicable, applies to offices as it does to, manufacturing and construction. But if an injury is workplace related and subject to this, if the work environment caused or contributed to the injury, or significantly aggravated a pre-existing injury. And so, that's going to be determined on a case-by-case basis, and it's really a more likely than not standard, right? Is it more likely than not that the work environment caused or contributed to this injury? And then
ultimately, who decides that? Is it a court of law?
If there's a dispute,
go ahead.
It's generally going to be an OSHA administrative law judge, right? If there's a complaint or an investigation by OSHA, and they have some findings. Typically, the way it starts is that there will first be, it'll first go before an administrative law judge at OSHA, and then there is potential review of that. There's one potential review that's still within the OSHA agency, or review can be sought in a federal court of the OSHA determination. So, right, it'll be initially determined by OSHA if it's workplace related. But again, when an employer is deciding whether or not to put it on this form, they're deciding based on the guidance from OSHA. And so it then becomes an issue if it's a recordable injury that has not been recorded.
Brad, tell me if I'm going down.
It's not just that it's. Go ahead.
Tell me if I'm going down an unnecessary rabbit hole, but I would think that it's probably not always black and white. Like if the employee is walking across the shop floor, they slip and fall, and they turn an ankle or break a leg. Okay, it's obvious it was in the workplace. But something that is, I don't know, maybe it's an allergy. An employee says, "Hey, I think there's mold in the air, and I'm allergic to mold. You're not providing a safe and work environment, but nobody else manifests this." Maybe as the employer, I think this person's, manufacturing a little bit of a scenario, or I'm sure there's types of injuries that maybe like a stress fracture that happens slowly over time, and it's not crystal clear that maybe this is because you play softball in a softball league, not from your work environment. How should employers be thinking about this on what to record, what to not record?
Yeah. So no, great point. And you're right that there is some, factual analysis required. I mean, some companies think that, well, if it's a workers' comp injury, then it's recordable under OSHA. But it's not. OSHA has this different definition. And I'll just note that, so it needs to be workplace caused or, contributed by the workplace. And it also needs to be a serious, a recordable injury, which means it results in death, missed work, restricted work, transfer to another job, or medical treatment beyond first aid, or loss of consciousness, or other significant injury. But yeah, it is it is something that, if unsure, a company should seek guidance, either from an HR professional or an attorney, because it's not just this OSHA 300 log. They are then going to have to fill out, this incident, the 301 form, which is an incident report and contains, information about the treatment and what occurred with the employee and the circumstances in the workplace, right before the injury occurred. So, it does create, compliance, with multiple forms here. And so, we don't just want to put down, every single thing that occurs at the workplace. You're probably being over-inclusive in that case. But at the same time, we don't want to miss ones that should go on there.
Brian, you said something really important, and I don't want to go too far down this path, but just the difference between OSHA requirements and an OSHA reportable injury versus workers' comp. Those are two separate things, but there's overlap because it's about safety and injuries. How should employers be thinking about the differences about how these are separate things?
Right. Well, I would just tell employers that consider, let's say the employee, is on workers' comp or makes a workers' comp claim. Keep that separate, right? We're going to analyze the OSHA recordable injury and what we need to do under OSHA entirely separate, right? We're going to look at, was this injury caused, contributed to, or aggravated by, a work-related event? And then does it, fit the, type of injury that OSHA requires? So, yeah, what I would say is keep the analyses, completely separate, that, one doesn't necessarily imply the other. And so, I think that's important because, OSHA doesn't, OSHA is not concerned with what, your state workers comp board defines as, a
Yeah.
workers' comp injury, that doesn't make it, OSHA recordable.
Got
And
it.
so I think one more thing to note on this topic is that, it's important, from, again, all employers, from offices to, more hazardous work sites, that companies should have an established written procedure for employees to report these work-related injuries. And OSHA finds that a reasonable procedure is one that isn't too burdensome, right? There aren't too many steps. That generally, it should be very quick and easy to report a workplace injury. And so, that's important to have something, in writing, right? That employers should know what the procedure is, that they should know they have the right to report workplace injuries, and that they know that, they won't be subject to retaliation or discrimination for reporting a workplace injury. So
That makes sense.
those are, we always talk about policies. It's important to have, policies relating to, reporting of injuries.
So, Brad, for record keeping, I've got the Form 300, I've got the 300A, and I've got the 301. Those are OSHA requirements where I log and track injuries. You've recommended, I don't think it's required by OSHA, but also recommended that we do record keeping around training, right? Training and enforcement. And so, hey, we rolled this out. Here's the class we had. Here's the content, summary of the content. And here's who was invited. Here's who attended. Here's who missed. Some type of note keeping. Do I have it right that that's not an OSHA requirement, but certainly it's a recommended best practice?
Right. I think in general, it's not a requirement. There might be some specific instances when it is, but right. Generally, not necessarily. But yeah, anytime you're doing training, and this is OSHA or otherwise, good idea to have it recorded, because you're doing the training for some purpose. And, if some related incident occurs, whether, it's OSHA related or anything else we can think of,
Yeah.
It's good to establish that there has been that training.
All right. So last topic that I want to go through is penalties. Is there anything else on reporting documentation required by OSHA that we need to talk first?
I think the only other thing I would mention is that these 3 forms we discussed, that those are forms that an employee can request to view at any time.
Okay.
And so, the log, for instance, of all those recordable injuries, that's something that I believe it needs to be produced to the employee within one day, right? The following day that they request it, it needs to be made available to them. So, these are things that, this is kind of an anomaly, right? Most records employers keep are, the company's records, like, personnel files, and, most states, those aren't required to be shown to employees. But for OSHA, these logs and, incident, for instance, an incident report should only be shown to the employee who the incident is about. But the logs and summary of the logs, the 300 and 300A, any employee can request to see those.
Got it.
So,
okay.
Obviously, that makes it very important to keep them. An employee who learns they're not kept might then report that to OSHA. Then you're dealing with a compliance issue.
Right. Last thing before we go to penalties, and I should have covered in the top of the hour. I believe I know the answer to this, but I wanted to just make it crystal clear. So many HR laws are dependent on. Sometimes it's industry. Some industries have different overtime rates. Sometimes it's based on size. So whether you have to comply with COBRA, whether you have to comply with the Affordable Care Act, depends on how many employees you have. OSHA doesn't care. You have one employee, you must provide a safe work environment, right?
Absolutely. So that's where their catch-all is the general duty clause, right? Where essentially, an employer violates this general duty clause if, the employer fails to, make its workplace free of hazards, and there's a hazard in the workplace that is either recognized by the employer or in their industry, and the hazard's likely to cause or has caused, death or serious physical harm, and that, the hazard could have otherwise been, materially reduced or eliminated by some, feasible means of abatement. So that's the catch-all that applies to any employer. And then for some other industries, there are additional, compliance, there are additional standards for, we've talked about construction industry, right? There's going to be standards about scaffolding, right? And things like that. So even if you're an employer that's not subject to any of those specific industry standards, that general duty clause applies to you regardless of the number of employees you have. And, it's something that requires an assessment of the workplace to see what those hazards are, understanding not only what you see, but what industry recognized standards are in your particular industry, and, taking, reasonable steps to eliminate or reduce those hazards.
Last thing I want to talk, Brian, is penalties and consequences. And I don't want to unnecessarily scare anybody. But I also want to just get real. So, how this is one of those things that I think so many people, again, if you work around hazardous materials, you're in construction, this is kind of a way of life for you. You probably already know a lot of this stuff and you live it out, but it's whom I worry more for are maybe, industries, businesses that operate maybe a little more on the fringe and think, oh, I'm a little white collar. I'm, of course, if somebody I can't have snags in my carpet where people fall, but this stuff doesn't really apply to me. I'm just I don't need an emergency action plan. That just seems like overkill. I do want you to unpack for us what are the consequences if you get it wrong, if God forbid there is an actual injury, maybe there's not a terrible injury, but you get reported, and what fines might look like. Help us understand the context.
Absolutely. So I'll start with, I believe in 2020 or 2021, the OSHA conducted over 24,000 inspections. Right. And, not all result in citations, but many of them do. And so if OSHA determines that an employee is exposed to a hazardous condition, right, and it doesn't need to cause harm, it may be one that is likely to cause harm, then it will issue a citation. And that's going to be something in writing, and citations are generally, issued within 6 months of the occurrence of a violation, and they go in terms of seriousness. So the lowest level violation is a de minimis violation, right? And, it's really not even a citation. It's just a notice of this violation. There was no direct or immediate relationship to safety or health, and there are no monetary penalties for that. That's the one that's not so scary. But then you have serious violations and other than serious violations, and each violation of those comes with a maximum penalty of $15,625. So that's where there's a substantial probability that death or serious physical harm could result from whatever condition OSHA has identified, or a practice or a method or operations, whatever it might be. But then the real bad ones, right, are the willful and repeat violations. A willful violation or a repeat violation carries a maximum penalty of $156,000 and $156,259. So that's a whole lot. Willful violation is going to be shown when the employer acts with intentional disregard to OSHA requirements. So that might be the situation we discussed where, someone gets seriously injured during an evacuation, and it turns out the company has no emergency action plan, right? That might be something that's willful because they've disregarded. It was a free-for-all. Everyone was running out of the facility, and people got trampled. That's, that would be, a willful violation potentially. And also the repeat violations. If there's a previous citation for a similar type of violation, and generally within the past 5 years, the company will get hit with that $156,000 maximum penalty. Of course, it could be lower based on circumstances, but they can go after that maximum amount. There's also, if there's an imminent danger, if OSHA sees something and it is just like we said, there's electrical wires exposed and they are getting wet, and we see sparking, something horrible like that, where there is an immediate risk that someone is going to get electrocuted or harmed. They can just forego their normal procedures and go into federal court to get an injunction against the company, unless the company voluntarily agrees to immediately abate that condition. And then
Brian,
so there are serious penalties here.
Brian, how do these things usually show up as investigations? So clearly there are higher risk industries, right? Road construction, roofing, that you're going to have. It's reasonable to expect at an undetermined frequency, an OSHA inspector is going to just show up on the job site, right? And so that's probably why most folks are somewhat prepared for that. It also, this is not legal advice, but it's also probably pretty reasonable, because I've never seen it in my career where an OSHA inspector comes into a white collar office and says, "Hey, I'm doing an inspection." Therefore, my fear is lulling white collar industries and businesses to sleep about what the actual risk is here. If it's like an overtime or minimum wage, these things often are, it's an employee, a disgruntled employee, former employee who makes a report. Maybe it's the Department of Labor, maybe an attorney files suit on their behalf. How do these things usually manifest? Is it simply whether you do or don't get inspected, or are there other means?
Right. No, excellent question. So there absolutely are, targeted inspections on certain industries, but those are actually the minority of inspections OSHA does. So of those 24,000 plus OSHA inspections in prior year that I discussed, the majority, I believe 57% of those were not targeted, meaning they arose because of an employee complaint, a referral from maybe workers' comp, right? An employee reports an injury to workers' comp, and it's pretty clear that there might be a workplace condition that OSHA would be interested in, or in an inspection, it can occur when you have a serious injury or a fatality. So there are many ways that an office, while your typical white collar office is not likely to be subjected to a targeted inspection, the majority of inspections are not that way. So it's going to be a complaint, and OSHA will just show up on site, right? Similar to a DOL auditor, for wage and hour purposes, and they are allowed to come in there with no advance notice, and they're going to there's usually a process. There's an opening conference when they'll discuss what the scope of the inspection is, the need for interviews, a walkthrough, review of records. Then they'll do the site evaluation and walk around, and then possibly interview employees, review documents and other things that might be relevant, and then they'll close the investigation and make their findings. So it's very important to understand that for employers, right? Because even if you're a white collar office, do you know what to do when an OSHA inspector shows up, right? Someone should from management should be with that inspector the whole time. When they're walking around doing the evaluation and the inspector is taking photos, someone from the company should be taking photos. So there's you don't just allow them to go in and get on with it. You want to follow them around, ask. The main tip I would give any employer, regardless of industry, when an OSHA inspector is on site doing an inspection, ask questions. Ask, about the scope, about what they're looking for, about issues. Absolutely ask questions. And also make the inspector follow the workplace safety standards, right? If a hard hat's required, make them wear a hard hat. If, there's employee screening, make them go through that screening. They're generally allowed to go in and, and inspect as they see. Of course, if they go outside the scope of the inspection, the company can try to rein them back in through, discussing that with them. If they see other things, right? If the inspector is there for one purpose, but they see, some other hazards, they're going to address those as well.
Yeah. Maybe the last thing I would maybe just add for guidance, and I'll let you close then, Brian. Whatever our topics we talk in this show, we talk about a lot of HR compliance stuff. And the goal is to give the best information we can so you can stay compliant, so you can build great teams and grow your business. A lot of times people make mistakes. They don't follow the law. And it's almost never on purpose. It's not people, I hate that law. That's a stupid law. I'm choosing to not follow it. It's unwittingly not following laws because the HR laws are so darn complex and they're changing so fast. And there's more and more of them every day. And the reality is, if you treat your employees really well and they know you, love you, trust you, and think that you have their back and their best interest in mind, you're going to get a lot of latitude from employees. If they think they're being wronged or they think they're in an unsafe work environment, they're probably going to tell you about it and give you opportunity to remedy the situation. But this just screams for this. And I keep thinking about all of the white collar type jobs where employers might not realize how much risk they have. That was a really important stat that you shared, Brian. 57% are not the result of a random inspection from an OSHA inspector. They're coming out of the result of injuries or workers' comp cases and whatnot. But also disgruntled employees. If a disgruntled employee goes into the break room and there's a switch plate that is cracked and you can maybe see some exposed wires. I mean, I've walked into businesses that you can just tell that thing has been there for years, right? And it's not okay. It's going to be an OSHA violation. But if all the employees love and trust and respect you and you're highly communicative and you show them respect, they're probably going to at least tell you, hey, could you fix that? That makes me feel really uncomfortable, versus just arms crossed, I hate my boss, I'm going to go report this sucker. And all of a sudden, you got an inspector at your door for something that was a 57-cent switch plate at Home Depot. So to me, compliance is compliance, and hopefully this is a helpful hour-ish conversation for folks to take OSHA seriously, understand what it is. At the end of the day, the best thing you can do to stay compliant is to have great relationships with your employees so that when things aren't perfect, you can work on it together and get them fixed. Brian, is there anything else specific, maybe comment on that, or specific on OSHA that you'd want to close with today?
Yeah, and I'll be brief, but yeah, absolutely. So I think the key is, like you said, if you're going to have, a good relationship with employees, excuse me, then, one of the things is keeping them safe. And, addressing workplace hazards is very important. And it can be as little as, a clean place to eat or clean bathrooms, right? Those are covered. So if you're a company that doesn't think this applies to you, think again. It very much does, and it pays to take these compliance steps.
Yeah, Brian, who knew we could talk so long about OSHA? I know there's a lot there, but the thing I hope everybody walks away with is it doesn't matter how big you are, what industry you are, where you are located. OSHA applies to everybody. Reiterate that stat: 57% of all OSHA investigations are not the result of some random audit where you got an OSHA inspector shows up at your door unannounced. It's the result of an injury that happened in your workplace, whether it was a work comp claim or somebody reported you that comes in from a different direction. So we have to provide safe work environments for our employees. We need to do it in a compliant way and in a way that shows respect to the employees to give us opportunity to remedy situations before they get ugly and all of a sudden you're getting issued fines for noncompliance. So, Brian, always love talking to you. Thanks for joining me today, and thanks for everybody else for sticking with us. We went a little bit over on time, so I really appreciate it. Until next week's show, we will see you later.
At Asure, we build human capital management software and services that help 90,000 companies like yours attract, develop, and retain great people. Our low upfront costs and affordable subscription model allow you to save cash to invest in things that drive growth, not overhead. To learn more about how Asure can help you claim up to $26,000 per employee with the Employee Retention Tax Credit, automate your payroll, and build productive teams that are compliant with ever-changing HR laws, visit AsureSoftware.com.